how does the length of time in the de facto relationship play in or relate to getting a prenup?
Good point. So most people should know that the earlier you do it, the better. So you can get one of these agreements as early as you like. I mean, you could do it the night after the first date if you wanted. I'd say that's pretty unlikely.
Thank you.
But generally, people will do it when that 3-year period is coming up, or when you're about to get married, or get into a civil union.
Yeah.
So that's something that people should know about. They should know kind of the general dates and know about the 3-year rule if you're not married, which I think is applying to more and more people these days, right? It's probably less common to get married these days. Certainly less common to get married as quickly as maybe 30 years ago.
Welcome to It's No Secret, a podcast for Kiwis who want their money questions answered.
Ready, steady, go.
This podcast will answer the money questions you may or may not have on your mind. We'll talk to real Kiwis and share truths about our own financial lives.
Both the successes and the failures. Because the truth is, there is no secret to achieving financial freedom.
Hello and welcome to It's No Secret. I'm Christine, and today we're back to chat about all things relationship property. Today we have a special guest joining us to share his knowledge on the topic, as I am by no means an expert in this area. I'm joined by Will Eddowes, General Manager at Agreeable, a Kiwi legal startup that helps couples get relationship property sorted online. Hi, Will. Thanks for joining us.
Hey, Christine. Thanks for having me.
No worries. Really excited to get stuck in. We've done a little bit of pre-talking and, I've got some really interesting questions lined up.
Yep.
Very relevant to Ollie and I as well for the listeners that know our relationship. Cool. So relationship property can be a bit of a sticky subject, particularly if you're approaching being in a de facto relationship, looking at getting married or otherwise, hopefully not getting divorced, but maybe that might be in the future. Hopefully not. But because on one hand you are hopefully in love and want to combine your hopes, dreams, etc., but on the other hand you also want to be financially responsible because you do truly never know what could happen. So lots to get stuck into. But before we whip into the questions, you have shared a few stats which are quite interesting that really set the scene on why this is important. So you shared that a report done by the Boren Foundation and the University of Otago in 2018 found that over half of those who discussed a prenup with their partner relied on non-binding verbal agreements. So you noted that this one was particularly important. Why is that, or notable to talk about?
Yeah, sure. So I think that the main issue with this area of law, particularly for most people, is the cost barrier and the kind of daunting nature of, we need 2 lawyers, which I'll talk about the requirements to get, a binding agreement.
Yep.
You need 2 lawyers to get a binding agreement, one each, and you essentially need to go through this formal process that is actually quite, it's a bit of an unknown for a lot of people. Hopefully after this podcast, for people listening, they'll know a bit more.
Yeah.
But that's probably why a lot of people end up getting just talking about it and not actually getting a binding agreement, not actually going through the steps to get, what a lot of people know as a prenup agreement or a contracting out agreement. And so, part of what I'd be keen to talk about today, and I think part of what I'm sure some people will learn, is that it's quite important if you are in that stage of life and if there might be some kind of assets that you don't necessarily want to share equally with your partner if things did go sour.
Yeah.
That there is a way to formalize it and protect yourself and, as you say, be financially responsible. And it doesn't have to be as hard as it used to be, thanks to Agreeable, but I'm sure we'll talk about that. So that's probably what I'd say is that stat is important because it shows that people talk about it. It's something that plenty of people discuss with their partners. They know a little bit about it, but they probably don't know it. Many people don't know enough to take that next step and actually protect themselves and be financially responsible.
For sure. I feel like even just the term relationship property agreement, I've definitely thrown around and probably not fully understand what it entails. And I reckon that people have this idea of I know it's something that I should do, but the gap between talking about it and actually getting one is potentially quite big. So that leads me perfectly onto what is a relationship property agreement and what does it entail? And you mentioned contracting out agreements.
Yes.
So set the scene.
Yeah, so there's a few different names, which is a little bit, I guess, a bit of a source of frustration for some people. I mean, every law firm is entitled to call it what they want. But, there is a way to define them, which I'll get into. But basically, I think the starting point is the Act. So the piece of legislation that the government passed in 1976, the Property Relationships Act, which has a lot. It does a lot of different things, but probably the main thing that it does for most Kiwis is say that if your relationship ends, if your serious relationship, and I'll get to what that is defined as, if that ends, then both partners have by default an equal share in the relationship property, which is its own definition, which I'll also try to explain. There's so many definitions and things.
Sounds very
but they're
legal.
not actually, then they don't have to be as confusing as maybe people might think, or some lawyers might make them for some people. Obviously, there's so many different types of situations, and by no means is this podcast a replacement for legal advice, but I think a lot of people,
financial advice,
a lot of people, I like to say, go in to get a haircut and they end up with a full body wax because they basically get so much more.
Do you mean kind of people go in expecting something and they come out with something so much
people
more?
People tell me on the phone, they're like, we both knew what we wanted. We went into a law firm. She went into a law firm. I went into a law firm. She went into a law firm. And we just ended up with these massive emails, and we didn't know what any of it meant. And so there's all sorts of definitions, which I'm sure we'll get to. But basically, for some people, that equal sharing law creates a fair outcome, and they would never have to really talk about a prenup beyond probably a bit of a giggle, and one of them sees it in a magazine or hears it on this podcast. But they've built a life together. They've saved very similar amounts. They've contributed financially very similarly, or one party is maybe earning more, but they're on the same page in terms of just
life and
life in
goals
general.
and,
They've done it all together, and that's a healthy conversation to at least have. But it could be a very quick one. But then for some people, it's not a fair outcome to just have the law tell you that if the relationship does end, sadly, that you both have an equal share of everything. And for some people, that might be because they've purchased a house beforehand. One partner purchased a house, and they would really think that that's their property. I mean, it might be different if you've been married or in a civil union, or you've just been living together for 20 years. But of course, if it's relatively early in the relationship, some relationships do end earlier than you think. You might still think that that's kind of your asset. And I guess that's where those situations are where the equal sharing law doesn't necessarily give the best outcome for some Kiwis. So luckily, there is a whole section or multiple sections in the Act devoted to contracting out, which is the basic term for parties being able to make their own agreement. So that's a prenup if you're still together, also known as a contracting out agreement, or a relationship property agreement, which is what we call it at Agreeable. But then there's also a separation agreement, which is if you've already separated, but you'd still like to make those decisions afterwards. So you obviously need to be relatively amicable and on the same page. But basically, there's two types: prenups / postnups. So you're still together, but it's early on, and then separation agreements. So that's post separation. So that's kind of, you've got another chance to divide everything and formalize it, which is usually something that the bank has asked for, or something that you both would like to make kind of moving on a bit easier. Those two agreements, which are all under the kind of umbrella of relationship property or contracting out agreements, are a concession from the law basically that says, well, Kiwis should be able to have their own option. But the law then says, the Act then says that you have to write it down, your agreement, your decisions. You then have to have a separate lawyer each, an independent lawyer for each person, give you advice and tell you what you'd be entitled to under the equal sharing law, or what you'd probably be entitled to, and then tell you what your agreement is actually giving you, or kind of what you're entitled to versus what you're getting. So that process, and then the lawyer has to sign it with you as well. So that process is, for some people that makes a lot of sense. For some people, they wish it was a lot easier. I think that, and most lawyers would obviously tell you that it is important, because some people don't actually know everything they need to know. And so that's the lawyer's role, is to fill them in on that. That being said, and I'm sure we'll get to this later, but I think what Agreeable is trying to do, and what we were made for, is to basically make that process a bit easier, because it doesn't serve kind of straightforward, amicable situations very well, because people have to go to separate law firms. There's all this formality and all this kind of like a lack of transparency between the two parties. They were amicable, and suddenly they're in separate rooms, and there's this gap between them. So we'll get into divorce. That. But so it's like that can be for a prenup when you're together, but you're in separate offices, and that can start making one of you wonder what the other person's being told, and we'll get on to Agreeable, but it's just a way for people to do it together initially and do as much of the process together. But that's kind of setting the scene on relationship property.
So
the basics.
Do you need so just to clarify, there's the contracting out agreement, relationship property agreement, and prenup. They're all the same thing.
That's basically you've hit the nail on the head.
Yeah.
So that's all usually talking about the one where you're together still.
Yeah.
Often they're called prenups because it's usually before marriage.
Yeah.
Because basically these agreements apply to, or this law applies to married couples, civil unions, de facto relationships of over 3 years. So you have to have been living together for 3 years.
So let's say prenup, I'm just going to use that for my own brain's sake.
Yep.
That only, how does the length of time in the de facto relationship like play in or relate to getting a prenup?
Good point. So most people should know that the earlier you do it, the better. So you can get one of these agreements as early as you like. I mean, you could do it the night after the first date if you wanted. I'd say that's
Please
pretty
sign,
unlikely.
thank you.
But generally, people will do it when that 3 year period is coming up, or when you're about to get married, or get into a civil union.
Yeah.
So that's something that people should know about. They should know kind of the general dates and know about the 3 year rule if you're not married, which I think is applying to more and more people these days, right? Like it's probably less common to get married these days, certainly less common to get married as quickly as maybe 30 years ago. So people should know about that. But that being said, the 3 year, obviously marriage and civil union, there's a kind of clear date, a clear point.
Yeah.
But a de facto relationship of 3 years, so living together for 3 years, you can still get an agreement and have that conversation and do the whole process later on, including after being married, or you can, the later you go while you're together, you can still have one. It's just a bit more complicated because the lawyers it'll probably be more expensive and more complicated because the lawyers will have more to untangle.
Yeah, right.
Because you have been together for so long that, I mean, if someone was trying to get a post-nup, like a prenup post-nup, and 20 years into a relationship, and they were trying to protect assets from their partner, of course, both lawyers, especially the lawyer for the partner who's not getting as much property, would say, well, are you just about to separate from them immediately? Are you just getting this prenup in anticipation of that? So that's an extreme example, but it kind of sets the scene for why the earlier the better, because things are clearer.
And there's less not baggage, but more to untangle, like you said.
Yeah, exactly. So usually a prenup is going to be, one party has a house, or maybe an inheritance, for example, which I think we'll get into as well, that they'd like to protect so that it doesn't become relationship property. Yeah. And that's very obvious 2 years in, or even 5 years in. But it's very obvious, I should say, that that's their asset if that's the conversation that you're having with your partner. But as things go on, you start to think, well, things have been a little bit more intermingled, which can actually make those assets relationship property anyway. Yeah. And it's not as clear to us anymore where the kind of contribution starts. Like, yes, you brought this asset in, but I've helped you renovate it, or I've helped you, I've been there, we've been part of this, we've either used this asset together. So it makes those conversations harder later. But that's probably why most people would say the earlier the better for a relationship property agreement.
So just also to clarify, is a post-nup and a separation agreement same thing?
They are different, sorry. Different. So a post-nup is, in the kind of colloquial sense, is a prenup, but it's after marriage. So you're already married. It doesn't really, you almost don't need that distinction. It's more just that, if it's too post the wedding, if it's too much down the track, then it does kind of define a more difficult agreement, a more difficult process. But prenups and postnups are similar, basically the same document, but just slightly different contexts. And then separation agreement does the same thing, but is for parties that have already separated, and they're kind of looking back and making that decision, in order to move forward with a bit more clarity. So.
Yeah, okay. Interesting. Now, I mean, there's a range of relationship types, for lack of a better term, i.e. partner, sibling, parent, friend, auntie, family, all that kind of stuff. And we're going to talk about the everything except partner shortly, because I want to use myself as a bit of an example.
Yep. See how that goes.
Sorry in advance, Ollie. But I guess the scenario and the kind of situation that I personally am in is that Ollie and I have been together for almost 5 years now, so we are past the de facto line. We don't have a relationship property agreement, and we obviously are not married. So I think you've kind of answered some of these questions, but when I look at what we've each brought to this relationship, Ollie has brought more in terms of assets and I have less. So knowing, let's say if I don't have get a prenup, am I currently entitled, and then we were to separate, would I be entitled to half of what we have together?
Big question.
Yeah.
So
personal situation.
obviously none of this is legal advice.
Yeah.
We're all clear on that. And I wouldn't want to be too specific. And I think I should start by saying a lot of these questions, or a lot of the answers to these questions are answered with probably or more than likely. Even a lawyer giving advice to their client can't necessarily talk in absolutes because it's all opinion based on the rules and how the rules and the law match your situation. The only way to get kind of formal definition is to go all the way to family court to really know where things stand. Yeah, exactly. So this whole process of getting an agreement and talking to lawyers is to avoid going to court. But that being said, I think I can answer relatively confidently to at least give you an indication. And essentially you would be very likely, if you've been living together for over 3 years, regardless of whether you're married, you would each be entitled to half of the relationship property. And it's good that we got to this point because I realized I haven't even defined what relationship property usually is for people. So that's kind of another source of confusion. So what is relationship property usually? I mean, it's almost always, in fact, by default, it is the family home. So wherever you live, wherever your primary residence is, presuming, one party or both of you own it. And that doesn't matter who bought it. If one of you bought it, 3 years before you even met, and then brought that into the relationship, it becomes relationship property. So the family home is kind of the big one. That's what most people have in their agreements, figuring out what they want to do with that. Then there's obviously the furniture, appliances. So those are the family chattels. So those are almost always, by definition, relationship property. They are. There might be exceptions, but there might be exceptions to a lot of these different rules. But in general, the family home, family chattels, income, so the bank accounts that you both use, as well as vehicles and any other assets that are for the common benefit of the relationship. And basically, the other element that's probably surprising to people is it's also anything that is intermingled with relationship property assets. So if you use your income on, let's say, a separate property that you both verbally say is, Ollie's separate property or your separate property, you both verbally say it's your separate property, but you're using your income to, renovate it or to contribute to it, or obviously you're using your income to pay,
property manager
pay
or something.
fees and things like that, then that gradually becomes more intermingled with relationship property, and it's almost certainly going to end up being at risk of being relationship property. It's also the case with inheritances and gifts. So if you get an inheritance of, say, $100,000 from a great grandmother or something, and if you keep that completely separate in your name and you don't touch it, you don't do anything with it, you just or you might do something with it, but it all stays away from the relationship. That's very hard to do, so I almost shouldn't even talk about that. You'd have to be so disciplined in particular. Most people, will use an inheritance on renovations or a deposit for a new house or something. So that's another thing a lot of people will contract out. They'll say, look, I got this $100,000 inheritance. Or they maybe early in the relationship and they haven't had it yet, but they know they're going to get an inheritance. They'll say, look, I think we need to get a prenup agreement so that I can protect that as my separate property. So we can use it to help each other while we're together. But if things go sour, if, the unfortunate happens and the relationship ends, I can protect that and I can, take that inheritance from my lovely great-grandmother back out of the house proceeds or something. So, basically relationship property is the family home, family chattels, vehicles, both partners' income, and the money, the bank accounts that they use just for day-to-day life, because the law presumes that your day-to-day life is for the benefit of both of you. And then any assets that basically are intermingled with those things. So it can be a lot wider than people think, a lot broader, and that's probably a shock for some people. Like if they do end up going through the process and they didn't know these things, they start to go, oh, well, I thought that gift was obviously mine, or I thought the house that I bought before the relationship was just going to be mine. But the law, that's what I meant at the start about how the equal sharing law doesn't always give fair outcomes to people. It doesn't always give kind of financially prudent results to people if they do end up kind of, moving into their own life. So that's why the option to contract out and protect things, while it's a tough conversation, is usually a really good conversation to have.
Yeah. It's funny as you explain what that is. I sit here and play through my own situation, but then I think about all the people that I know in like family situations and stuff where I'm like, "Yep, you're on de facto. You need to get this, and this is going to happen here, or what if this happens?" And it's like, I mean, I think it affects or touches everyone in some way, regardless of whether you're in a relationship with someone or you are in relationship with someone in your life, whether that's a family member or a partner or whatever. So it's very relevant.
Yeah.
Love that. So that's basically I need to get a relationship property agreement.
Or, think about it. It's certainly not my place. And even Agreeable, we don't necessarily go tell everybody to get one, but we would tell everyone to have that conversation if you're in that kind of stage of life. It's something that probably catches people off guard, and the downsides are, messy disputes, claims by an ex-partner, potential kind of trips to the family court, things that if you ask the many people in family court now going through those things, if you asked them 5 years ago, did you think you'd be here? Almost everybody would say, of course not. We were just a normal couple. But sadly, without trying to scaremonger anything, that is what this whole system is designed to avoid, because that system doesn't help, obviously, couples, and it doesn't help New Zealand and our justice system. It fills it up with situations that could have been dealt with earlier by just maybe a couple that was a bit more prepared or knew, but had a bit more information at hand. So,
yeah, definitely. So I think, when I think about Ollie and I specifically, I'm more than happy to have that conversation. If anything, I'm probably a bit more forceful than maybe he is. But I don't think that that's the case for the everyday person, because it is quite a tough conversation to have. And you kind of touched on this earlier about, maybe you do it after your first date if you're really that way inclined. Probably a little bit aggressive. Yeah.
That was just a kind of extreme example. A possibility, but
Totally. Yeah. But you must speak to couples or people all the time that have had those conversations. Can you give any insights as to how someone would go about approaching that topic with someone in their life?
Yeah, it is a touchy subject. It's almost, for some people, it's almost more of a kind of, a mentality thing. It's almost a psychological thing. So it does depend on kind of where you sit in the relationship. And I would never kind of intend to, or I'd never say that everybody should have these conversations. Some people, for whatever reason, just it might not be an option.
My parents went through a separation or a divorce that lasted 12 years, and they were in and out of court and all that kind of stuff. I can't even imagine the amount of money that was spent arguing, let alone the mental strain and the impact on the kids and all that kind of stuff, right? And so I think for me personally, that has inadvertently freaked me out, because I'm like, I have to be protected and I also want the other person to be protected. But then it scares me to be like, my sister needs to be protected and she needs to do that. And, because the worst case scenario is pretty dire. And I think that everyone knows someone that has had a breakdown in a relationship and it has potentially not gone well financially, and then you're worse off, because that could be the difference between a secure retirement or not, right?
Yeah. Yeah. Kind of financial security but if you're by yourself, Yeah. No, those are great.
Yeah. Sorry, that was a bit aggressive. But
no, that was really good.
I think that is the reality of it, right?
It makes me feel better about saying that stuff, because I know, I know that some other lawyers would go on these things and be like, it doesn't mean, talking about prenup doesn't mean it's predicting doom or anything, but it's like it's not predicting it, but it's preparing for it.
Yeah.
In all honesty, I think it's about understanding what the worst possible outcome is. And that's a little bit daunting and maybe something people don't want to think about, but it is. We were talking about this earlier. It is a little bit like insurance. Like you have insurance not because you think something's going to go wrong necessarily, but just because if it does, you want to be protected.
Yeah.
And we all know somebody who, everybody knows someone who's had a breakdown in a relationship. Sometimes that ends up being a financial thing, claims and kind of spats and things like that, probably from couples that never had those conversations early on.
Yeah.
And so I think having that transparency and honesty with each other, again, I can't speak for everybody, but I don't think it's a bad thing to say that most people, that everybody should think about whether that's a good conversation to have. And for most people, it probably is.
Yeah.
And it is a tough conversation, but it's one of those things. It's just one of those kind of life admin things that it's like, it's not necessarily nice to have, but in some ways it could be, just to be open with each other.
Yeah.
And I think like I said earlier, at the very start. For some people, they've built a life together. They've started with kind of, just their incomes or something. They bought a house together. They've done everything together. And that may be a lot faster and easier conversation. But when it does seem to one partner that this conversation could be important, and that maybe getting an agreement and getting something legally binding could be important, then I think if the other partner was a bit unsure about why we would talk about this, it's just about knowing that there are a lot of people who have unfortunately had breakdowns in the relationship, and situations go horribly awry when maybe a little bit more of a discussion while things were good might have actually avoided that. Not necessarily in all cases, because sometimes things just changed far too much. But
so a little bit tangent, but on this note, just to counter the why do we need a prenup thing? So I was watching this reel the other day, and it was talking about this lady was like, I purposely did not get a prenup, and I didn't want to, because basically the agreement was that I was going to be the stay-at-home caregiver and mum basically, and my partner was going to be the breadwinner. And what if he decides to leave me? He's built up this career over time, and he's got this huge ability to earn, and then 20 years later what am I left with, other than obviously a beautiful family and that. But then so if you said before, potentially in my situation I would get half of what Ollie has. Have you ever heard any such situations of people coming in with that mindset, and or do you see validity in that? Because I know that there is a big discussion about, the roles that people play in the family and as providers and all that kind of stuff. And it's the career element, the ability to earn. Thoughts? Yeah,
so I certainly believe in that. And that's, I think we all maybe feel like the politicians in government are doing not a bad job sometimes, but they, we're like, well, what are they doing in there? Luckily, in 1976, they kind of thought about that stuff already. So the whole point of the equal sharing law, really, or a big part of it, is to recognise non-financial contributions. So it's to say that just because one partner didn't earn as much money during the relationship, they may have been, doing more parenting, or they may have been more responsible for thinking about kind of broader things in their family rather than just, contributing, earning money for the relationship. So that is certainly something that feeds into why we have an equal sharing law. And I would say that if that is a relevant thing to, both of you, or at least to one of you, and something that you hold quite dear, then you have every right to not sign an agreement and to not even think about getting one, just like the person in your reels. So it's, that means basically no one can force you to sign a prenup. And that's probably something else that's important. Like here we are talking about all the basics of the law and kind of what you should think about when you're getting one. But I think that you bring up an interesting point that we should definitely mention, which is that nobody can force you to sign one. It's all about having both parties' agreement and consent. And if anybody has been kind of coerced into signing one, then that agreement is probably going to be set aside, or will have a big risk of being set aside in the future. So, essentially you don't have to have an agreement. That obviously might cause some friction for people if one partner does and one doesn't. But no one can force you into getting one. And that may be a source for some kind of
contention.
That just is a fact of our society, that there will be people who just decide, I'm not going to get one. And if the relationship does end, then they're going to have to sort that out, and those conversations might change, or things might change. But the law does protect those people that's what the equal sharing law is for. So for anyone out there that's like, oh, I'm learning about this equal sharing law and it sounds dreadful, it sounds like it makes no sense. Well, it makes sense for those. It makes sense for people who, don't have anyone to necessarily defend themselves when they say that I didn't earn as much money, but I made my contribution to the relationship in other ways. So those people are protected, which is, I think, a nice feature of the law.
You could write that into a contract though, right? Surely.
Right in what?
In terms of, let's say you both agree that you want to get a prenup, because let's scenario. In the example of me and Ollie, if we were to decide that we were going to have kids in the next year or whatever, and Ollie has brought in more money than I have, but then I'm going to be the person to stay at home, we could be on the same page that we want to get a prenup, like at that point, or now, let's say. No, but he could have his initial assets like protected, but we could write into that contract that this is the non-financial contribution that I would be making, and therefore, you know, I would be protected. Or is it underlying? Does the Act already protect that? Do you know what I mean?
Yeah, the Act already protects that.
Yeah.
So basically, if that scenario was occurring and you wanted those things to be, I guess,
Acknowledged.
Yeah. They already are by the law. So you would basically be able to say, if that was important to you, in that situation, you'd be able to say, well, I don't ever have to get an agreement because the default of the law is that my contribution is seen as equal. And as part of that, if the relationship ended, I'd be equally entitled to the relationship property. Mm-hmm. Some people might customize a prenup agreement to basically say that, look, this is how things stand now. So this is her separate asset or his separate asset, but we're going to review it every couple of years, or we're going to review it once we have children, or I've seen some people have kind of conditional, like time frame based things. So after X number of years or something, then the other partner's share in the property will increase, even though they didn't contribute initially to it. So it's these are very flexible agreements, but which is great. But they obviously have to be fair, reasonable, and agreed by both parties. And obviously they need to have the legal advice from a lawyer each and go through that process. So that process of having the lawyers may change some things, but if it's something that's important to both of you and you can agree on it in conversation, then it probably, if it's going to move you away from the default equal sharing law even a little bit, that's when you might consider getting, contracting out and getting an agreement. Yeah. But if your decision, if your preference, your agreement between both parties is to basically have an equal share anyway, even though one of you hasn't contributed as much financially, then the law protects you, so you don't actually need an agreement. Although, if things went sour and you did end up kind of having a dispute over that, that's another story. But yeah.
Okay, cool.
I hope that kind of answers.
Yeah, nice. Great. I'm like banking all of this. Okay, so moving on to other types of relationships. We've kind of trickled parts of it throughout the conversation, but I wanted to start with family. Now, I don't know about you, but we are reading more and more stories about, family helping other family members into property ownership specifically, or, perhaps it's in the likes of an inheritance or something. We found some interesting stats around this. Consumer NZ 2022 research found that 14% of all families have supported their kids financially to buy a property and assisted them with an average contribution being $108,000, which equates to roughly 208,000 parents. So that to me says that it's obviously something that's happening. There naturally is some legal stuff around this. So curious to understand what the different options for parents are, and could you explain some of the pros and cons of each, i.e. gifting, loan, guarantoring?
Yes, absolutely. So I'll probably start with guarantoring.
Is that even a word?
Yeah. Basically, it's, speaking generally, without getting too specific, most people, if they have a guarantor, it would be their parents or maybe even their grandparents being a guarantor over their, I guess their mortgage and their responsibility to the bank. And that, I'm not sure if that was more common in the past or not. I don't have kind of the data on that. But what I do know is that most people, most lawyers, even the banks themselves, do not prefer that option. And certainly the kids and the parents or grandparents shouldn't either. Again, this isn't legal advice, but just the general, people should be very aware that a guarantor can end up being liable, having their home be liable. So if your parents, for example, were the guarantors for your mortgage, their home may become security over that the bank would necessarily ask for and take. If the kids weren't able to, I guess, pay the mortgage, so that's something that people should probably steer away from. Again, there might be some technicalities that make sense for some people, but that's the general things I hear from lawyers that is kind of the consensus view on guarantors. If you do want to, tap into the bank of mum and dad, which, as you say, is increasingly necessary for people, and it's more common. Probably getting a deed of debt is the best, a deed of acknowledgement of debt. We just call it a deed of debt at Agreeable to take, to save one big word, acknowledgement. But deed of acknowledgement of debt, which basically is a very simple document, or in most cases very simple. Some people may, need or choose to complicate it. But all that document says is that the parents don't, have loaned their child $50,000 towards a deposit, and it will state the terms in which that has to be repaid. Most ones that we see would be people who that the kids will repay it once the house is sold. So it's kind of this, undefined future, this future date, but conditional on the house being sold. And in a lot of cases, that's quite helpful, where the child who's getting loaned to has a partner. And basically the parents want to protect that deposit so that it does become a relationship property thing in those situations. Because if the partner, if the partner is entitled to half of the home as well, because if we assume that it's a family home and relationship property, then if in the future the relationship ends, that $50,000, debt to the parents is actually absorbed into the home. And so the child's partner has a half claim of that. Basically, that money disappears from the family. Whereas if you have a deed of debt, which states that the parents actually loaned that and that they are entitled to receive it back upon the sale of the home, then money is inherently protected as the parents' debt. If it's a gift is probably a little bit easier, a deed of gift. So that's basically just the parents are giving $50,000 to their child for a home. That's important to get in a deed as well, just really to show the bank that it is a gift, that it might help the child to get approval for finance, because the bank sees, there's this kind of no obligation $50,000 gift, so the child is going to be easier. It's going to be easier for them to meet the requirements of their mortgage. But then if it's a gift, that becomes a deed of gift, that becomes a lot harder to protect from a relationship property situation. Even if you have a deed of gift, it can be seen that gift has been absorbed into the relationship anyway. So we would probably say to most people, if they are getting gifted, $50,000 from their parents toward their house, and if they're in a relationship and they'd like to protect that, then that's when you'd probably get a prenup that mentions the deed of gift, that mentions the gifting, and that partner or the child can protect that $50,000 as their separate asset. Again, like for the stuff we've spoken about, just in case of the kind of worst case scenario. So that's probably some of the things people can think about. And the legal requirements are pretty minimal. It's basically legal requirements are minimal, so you can actually get a deed of gift or a deed of debt just by having a witness sign with each party, witness each. You don't need legal advice, but it's highly recommended. I know some lawyers actually just wouldn't write up a deed for you without also giving you the advice. So that's certainly recommended, but it's not a necessity like it is for relationship property agreements, where you literally do need a lawyer each for the agreement to mean anything. But a deed is kind of quite simple. But
interesting. So that would, I guess, also like these kind of gift loan guarantor scenario, also like thinking, blowing it out to other types of relationships, the idea of a deed of gift, a deed of acknowledgement of debt.
We say deed of gift, deed of debt.
Deed of debt, yeah. Like it would be the same thing if you were, let's say, going, I don't know if that would apply, and on a house, let's say, with friends. Like,
so that's
completely different.
That's again, there might be certain elements. I don't know if there are many people out there getting gifts from friends, but I think in a different way.
I realised as I said that.
In a different way though. A property sharing agreement is probably more suitable for that kind of situation. So we see a few of those pop up where people are basically, again, it's another way to kind of defeat this issue of house affordability, right? To go in with mates, go in with your siblings. I know some of my friends have done it or are in the process of doing it, and getting a property sharing agreement in place is, again, this isn't a relationship property agreement, so doesn't have those requirements, but it does protect all the parties by basically saying who contributed what to the deposit, how are we going to deal with mortgage repayments? You know, is it going to be an equal share? Sometimes people go 50, 25, 25 or something. What will happen if we sell, or if like one party wants to sell? Do the other parties want a right of first refusal, which is basically that they get the chance to buy the share first?
Let's say one person did want to sell, would that then trigger everyone else to have to sell if they weren't willing to then buy?
If they weren't able to, yeah. So so that's it. It's that if the rest of the team weren't able to cover those costs, then they'd all have to sell, and then the agreement might put some kind of agreed terms in place around how that would happen, how they'd decide. So a property sharing agreement is a relatively simple document. In some cases it can be, like if it's equal shares and if they all just kind of want the standard clauses. So we sell them at Agreeable, and people can basically just fill out the online questionnaire on our app, and it generates one for you, and then our team would help you. Some people obviously can go and have lawyers do it, which might be certainly good if it's relatively complicated and you don't know how to start. But if you know a little bit, you know, we have a guide online and things like that, then you can at least get started with it and then get legal advice afterwards if you choose. Again, legal advice isn't a requirement on those, but isn't a statutory requirement. But most people, when they're buying a house, will have lawyers involved for conveyancing. So you should probably wrap your property sharing agreement into that. Whatever your lawyer's helping with you in the home transaction, you should also probably get a little bit of advice over the property sharing agreement. Sometimes it's good for, you know, everybody to have their own lawyer in that situation. But if it's just a few friends kind of having a relatively simple co-ownership agreement, then maybe one lawyer can just help all of you, you know, figure out what you're doing. But it's those agreements are better options for that co-ownership, siblings, you know, friends, flatmates. It's
nice. Okay. Going back a little bit to the relationship property agreement, I noticed that you mentioned family home a lot.
Yes.
Does that differ to like an investment property?
Yes, it does. Yeah. Okay. So basically, the family home is where you live, primary residence. That's usually easy for most people to define. I know at Agreeable we've seen people with yachts as family homes, or we've seen people who have they've rented the whole time, so there isn't a family home, but they might be getting an agreement because there are other assets or other intentions that they're trying to reflect. But if you have an investment property, almost by rule that will be considered for the benefit of the relationship, so that would immediately become relationship 50, property. 50, it's at a very high likelihood. I would almost say guaranteed. I mean, it's very hard for one partner in a committed, healthy relationship to like have an investment property that the other person doesn't at least benefit from in some way. From, you know, if the partner with the investment property is getting income from the investment property, like being paid rent and using that rent at all to benefit the relationship, then that investment property becomes more and more likely to be relationship property. So there are obviously exceptions and outliers, and people can be very particular about how they protect assets in other ways. But I would say an investment property is if there's an investment property that one of you purchased before or purchased with your own money during the relationship, that might be when the conversation of a prenup starts, to basically say that, you know, the partner that purchased that would like to retain that. Because obviously while you're together, you can still benefit from that investment property. It's just the prenup in your agreement is just saying if the relationship ends, this is what will happen to the property. But retaining it as your separate property during the relationship through a prenup doesn't mean that you're refraining the other party from coming to the batch on holiday, or from, you know, or even from having the rent from an investment property or Airbnb income or something help you guys pay your family home off. It just means that you're protecting it in case of the worst possible scenario.
So how does having an individual will come into things? You know, in the example, let's say, of having kids, I obviously know that that's not what the conversation necessarily is about today with regarding kids, but let's say Ollie and I have individual wills and then we join forces, you know, in a relationship agreement. Surely those, and I'm like, I want any of my assets to go to potential future kids. What needs to happen there?
Yeah, sure. So essentially, probably the main thing is one party can't use a will to defeat a relationship property claim, because obviously if there's a prenup, then you've made that together. But we would say to most people that, you should update a will to reflect your prenup. And certainly if you separate and you have wills, or if you don't have a will, you should get a will or update your will to reflect that, reflect the new decisions you've made around your assets. Basically, that's so that there's a much lower risk of dispute between the surviving partner and the estate of the deceased partner. It's probably something I shouldn't touch on in too much detail, because there are estate laws that are not really my specialty.
Yeah.
So if that's a consideration for people, that's certainly something, if people are in that situation, go seek legal advice, like talk to a lawyer in your area. That's something to deal with probably in person, because it's quite,
technical.
Kind of heightened, and, someone's deceased. I mean, it's a big deal. But we would just generally say to people that, the surviving party can often, they generally get a choice between what they're entitled to under the laws of relationship property and what is in the will or the intestacy laws from the other partner. And those things can be in kind of intention if things that haven't been aligned. So, and all that can do is just lead to kind of arguments between the kids or previous kids of one partner and of the deceased partner, and then the surviving partner. So I would keep it simple and just say people should realize that you should update your wills alongside having these conversations around relationship property.
Okay, so we've talked a lot about different agreements. How much do each of these cost? Like, what could I typically expect to pay if I was to come to Agreeable, and then Ollie as well?
Yeah, good question. So Agreeable generally tries to make it, and we really do for most people, a lot more cost effective purely by helping you together and having lawyers who collaborate with each other. It's fully online, so there's just a lot of steps in the traditional process are taken out, or at least reduced. I would say I'd start with the kind of traditional costs. So a lot of people using in-person lawyers will end up paying upwards of $5,000 as a couple for even quite a simple agreement. That just includes a lot of time for the two lawyers who often don't know each other to correspond and communicate. Obviously, you've got to draft it. So if you get it with an in-person lawyer, they'll usually sit with you. You'll have an appointment, and they'll draft it up with you, and then you'll have to take it to the other lawyer, your partner's lawyer. And if they don't like it very much, or if they have a different view, then that starts this whole process of
back and forth.
The lawyers saying, look, I know this is starting to seem ridiculous, but we've got to protect you. So that doesn't speak to every family lawyer around the country, but that's just a part of the kind of the old model, or the traditional model. So what Agreeable does is basically you both come through us together. You start by drafting it on the app. So it has a little DIY element in that we best serve people who have done a little bit of research. You'll obviously get legal advice later in the process, but just to draft it and just to kind of get something on paper in a strong template, you can draft it with our app, which fits your answers into a template designed by our lawyer panel. We have about 15 excellent lawyers around the country. And so that costs $450 with us to initially draft it, and then have any help from our team to basically, we've got an operations team that helps people, if people aren't sure what a clause means, or they're not sure, if they're a little bit concerned that something kind of reads funny, we'll help clarify things for them without giving them legal advice at that stage, without having them pay for legal advice. But usually the people that have found us are, it's quite a straightforward situation, so they're kind of smoothly through the process. Then once everything's drafted and finalized, you need to have the agreement certified, which is where you have a lawyer each, give advice. One partner has lawyer A, one partner has lawyer B. And that process with us usually costs about $2,000 to $2,500 in total. So for both the couple, so we give fixed quotes to basically just have a little bit more transparency.
Set expectations, I guess.
Set expectations. It's hard to give fixed quotes in the law because people always think their situations are easy, so they expect a kind of minimal cost. But what Agreeable tries to do is handle a lot of that up front, help people initially, let people kind of drive the process themselves, and then give the lawyers a lot of context, give them an agreement already drafted, so that it minimizes the role that the lawyers have to take. Because the big expense for these agreements is obviously the time with your lawyer. Like, it's a few $100s an hour for any lawyer in the country. And, that's important. Lawyers are very important. But there are certainly kind of features of the old way of getting these agreements, which is still the normal way, sadly to say, but Agreeable's trying to change that, of kind of having this gulf between the two lawyers and the two partners, we think people can save a lot of time and money kind of just doing it together.
Yeah, cool. So Ollie and I come to you, we fill out this form, that's $450. The information that you're taking at that point is what?
So that's you and Ollie would have had the conversation around, we've got all these guides on our website and articles. So you read those. You might get in touch with us to make sure you would say, hey, Agreeable team, we're about to buy an agreement. We just want to make sure we've got everything we need to fill out the questionnaire and generate the first document. So you'll be bringing, what the address of the home is, what you're doing with the home, if there's an investment property or an inheritance, any of the assets that you've figured out that you would like to include in the agreement. Whether it's yours or Ollie's, it's shares. You bring that all to the questionnaire. Yeah, shares. It can be bank accounts. People, if it's a prenup, people might state that their incomes would like to, remain separate in the event of the relationship ending. Mm-hmm. Bank accounts, Kiwi savers. Yeah, so you basically bring the list of assets that will go in the agreement. Mm-hmm. And as I said, we have a few kind of touch points on the website and a guide to list those out for you and try to make it clear. Yeah. If people are just absolutely not sure, obviously the option of going to lawyers straight away is always going to be there. Mm-hmm. We just try to be an option for people where you've done a little bit of legwork yourself, you've done a bit of research. We think that is possible for people. Some lawyers out there probably say it's not, that people should just be with a lawyer straight away. Yeah. But we help a lot of people who know a lot about how the law works for them and their situation, and they're kind of ready to go. And so that's what people do with us. They bring everything. We refine it, touch it up. We answer questions and then pass them on to lawyers at kind of a pretty low fixed fee to have the advice and everything. So at the advice stage, when they're with their lawyer each, some things may change slightly. If they change a lot, we obviously at Agreeable, we have kind of protections for the lawyers so that they're not giving a fixed quote for a case that blows up. But we generally give the lawyers enough context so they can commit to a pretty low fixed fee because they know both parties have been spoken to and worked with our team on the initial agreement. So yes.
So that was my next question: is how do you take that information as Agreeable and then say, okay, the fixed fee is this? Is that a standardized fixed fee, or it would change per case?
It changes per case. Yeah, we have kind of broad ranges, but we can't commit to anything. We would love to just say there's kind of one fee for everyone, but we have to protect the lawyers by letting them say what they'd be happy to work on it for. So we combine the two lawyers' quotes, add a fee for our services, and then present that to the customer. So the couple can pay together, they can divide it how they choose, but the quote is for both of them. So we just find that makes things a lot easier than the old way or the traditional way where you each get a bill at the end, a mystery bill, which is from an hourly rate, which could be without throwing any family lawyers under the bus, some of the things I hear on the phone from people who have found us because they're either a past situation, maybe a previous separation or a prenup they did earlier in their life was just way more expensive and far longer than it had to be. So that's what we're trying to stop for most people. But some people do need a long process. If it's, if you have trusts and if you have businesses, multiple businesses, then there might be a little bit more particular attention that a lawyer needs to face. But even then, if those come through the Agreeable system, we flag all that for the lawyers so they can quote accordingly. So even then we're able to usually give a fixed kind of transparent quote and let people know what it's going to cost. But I should say that some people do find even cheaper options, like they find a kind of local lawyer who's willing to do it for maybe $600 each or something, or $1,000 in total. And we would just say steer clear of those or be careful of those, because that just sounds like the agreement's getting pushed through with kind of minimal advice. And I think even we at Agreeable get a little bit of stick from some family lawyers for being too fast, for kind of, informalizing the process. But we still have a minimum cost with our service. We still make sure the lawyers are all accountable to make sure the agreements are fair. So, we're not necessarily the cheapest you'll ever see, but if there's anything in the world to not scrimp on or not kind of be too
tied on.
Yeah, is a good word. It's probably legal advice. But the other way is also the case. If there's anything where you can waste your money, it can be legal advice as well. So
so on that, because let's say I I mean, it's kind of like the agency model, really, of a traditional law firm, let's say, that where you have your directors or, your real super senior and they charge out a higher rate and you've got your kind of interns or lower junior staff.
Yep.
How do I know when I come to Agreeable that I'm not going to get the intern? Like, do you have a bar where you're like, okay, senior to intermediate or intermediate to senior to director, like this is the level of advice in terms of seniority or experience that you can get through us?
It's a good question. We basically let the firms decide that, but I know they wouldn't. I mean, I know who our lawyers are, and they're not putting kind of interns on, or
not that there's anything wrong with interns.
No, interns in the future in many cases. But our panel is full of at least solicitors, so people who are completely qualified to handle these. They do lots of them in their normal work, but then Agreeable is kind of another way that they get clients from anywhere in New Zealand because our service is online. And so that if a lawyer on our panel says yes to helping a couple and they're a partner or maybe a kind of senior solicitor, then it might be a couple $100 more. Yeah. But we basically just don't differentiate between the lawyers because all of our lawyers in our panel are experienced and experts in this area, and they've done hundreds of them before. So
and then so I liken this also to the financial advice where you can pay for a fixed fee or fee for service, where you get a financial plan, or some advisors charge, or most advisors charge, an underlying management fee on your total portfolio balance or KiwiSaver balance or whatever you're getting advice on. And oftentimes finding it's like a relationship fit, right? Where you, in the same way it is for like a psychologist or, those kinds of things where you are like, okay, I want someone that I can see in person in Auckland versus online if they're based in Dunedin or whatever. How do you match like me with someone that might fit? Or is it a little bit more, not transactional, but like, do you know what I mean?
Yeah, I mean, we have a few lawyers who tell us the kind of work they prefer to do. Yep. So it's a lot easier for us to manage from that side because we have great relationships with the lawyers. Yeah. But in terms of matching specifically, I mean, we're fully online, so we don't – if somebody requested in person, we could do that if one of our lawyers was in their town or city. Yeah. But in most cases, people have found us because they love the online element. They love that they can do it from home. It's a piece of life admin. They don't have to drive into town for and find a car park. And, I'd say something I should add is the kind of traditional way generally takes several months at least for even very simple situations whereas Agreeable takes a couple of weeks because – we kind of organise the lawyers for you. The lawyers are ready to go. They can fit it in because it's online. They can fit video meetings in and calls in with you between other kind of in-person things. So there's a lot of time frame benefits for the Agreeable process. Yeah. But in order to get those, we kind of don't spend too much time perfectly matching people. But what we know is that all of the lawyers are great, and they all, we don't put any old person on our panel, any old lawyer. We make sure that they've done a few files, that they we talk to them, we bring them on, we have a semi-formal relationship with them. They don't work for us, but that's so you can be you can be assured that you're getting a good lawyer. Yeah.
I think the reason I ask, and I'm obviously selfishly projecting, I think it's natural to be biased, but when I think of a legal agreement, I personally want to know that I have someone that has my best interests at heart, but also can understand the challenges that I may face that are unique to me versus, let's say, my partner. And not to be gender based, but inherently, like there are certain gender roles that tend to, take place in relationships and in life, really. And so coming back to, being the homemaker and stuff, I want to make sure, and also, as the person that can give birth to the child, I need to take a career break, right? And how does that impact me financially in this legal agreement? Will certain people understand that? I think that's the perspective, just to give a bit of context as to why I'm asking these questions, to know, like, how do I know that I'm going to get matched with someone that is, like, on the same page? Do you know what I mean?
Yeah, it's a good question. I mean, obviously the fact that all the lawyers in our panel, I can't speak for wider lawyers, but they've all done so many different files, helped so many different people that they would have helped people in all those situations, kind of both sides,
walks of life,
all walks of
scenarios,
life, all genders, everything. Yeah. And so I would say that if that was important to you, if you were using us, you could request that. You could say, look, this is important to me. Yeah. If it's not, or if you didn't even know to ask, then I suppose you just trust that, we're providing you with a good lawyer. But it's also something that I'm sure some people do choose the in-person way because they're kind of they might have to bounce around a few lawyers before they find one who's a great fit for them.
Yeah.
It really depends on kind of your needs. And in terms of what you said about whether having your interests in mind, I would say that's a big part of the Agreeable model, just having lawyers who are kind of cost conscious and they don't want to initiate conflict.
Yeah.
They want to work with the other lawyer collaboratively and kind of in a no-nonsense way without, it's just a side effect of the old model that because it's hourly rate, the lawyers, while they're not necessarily trying to extend things, there is an active incentive for them to, push on things that sound like a potential for conflict or not create disputes where they're not there, but actually kind of, if the clients, if you and Ollie don't want any, you're so amicable and you just want to get this sorted and kind of move on with life.
Yeah.
You don't want all those questions and
the
triple questions
stuff,
and like, have you thought about that? Have you thought about that around stuff that, there'll be a minimum, a certain amount of things that, I think some lawyers call it like crystal ball gazing. So they're looking for a prenup into the future. And all of our lawyers will do that with you. They just, will not push on things that might create, unnecessary conflict and hesitation that you and Ollie didn't want. So I would say if there's anything that's a real area, a real, aspect of this area of law that could, I think, be better in general, it's being better for the clients, because sometimes their interests are, maybe I'm going to be the homemaker for a bit. I'm going to be, sacrificing certain things in my career, and I want that to be reflected in the agreement.
Yeah.
That could be important for you, but also what could be important for you is to not have a months-long dispute.
Yeah.
And I would say that's
going to cost me maybe
cost
all the
you more.
contributions I would miss out on.
Exactly. So it kind of defeats the whole point of why you're doing it, right?
Yeah.
So that's probably what I'd say in general on that. Yeah.
Yeah, nice. Love it. Cool. So where can someone find Agreeable? I assume it's agreeable.co.nz.
Yeah, that's right. Yeah, it's agreeable.co.nz. People can get in touch with us. We obviously don't provide legal advice straight away in terms of acting like your lawyer, but we can help you with, really quite pointed legal information.
Cool.
Kind of translate some of these concepts to your situation without advising you on what to do necessarily. But we just think that's another thing that people shouldn't really have to like book time with a lawyer to get basic info. There should be a kind of certain level of reading up and asking questions that people can do just for free. So I'd encourage anybody who's thinking about any of these situations we've talked about, feel free to get in touch with Agreeable and we'll just help you because it's a nice thing to do. So
yeah, nice.
Yeah.
And just to clarify, it also extends beyond just like couples. It's the full span of relationship property agreements in terms of like deed of gift and deed of you do all of
so we
that,
do relationship property agreements, which are the prenups and separation agreements. Then we also help people. We have so our deed of debt and deed of gift and wills are $89. So that's just to draft it.
Cheap.
And we'll also, we'll give you a bit of help on kind of tidying it up. But if you wanted to get legal advice, that's obviously kind of optional and extra, certainly recommended. But we can usually arrange someone from our panel to give you a quote for those. And then property sharing agreements are $199. So again, that doesn't include legal advice, but it does include help from our team to kind of sharpen it up. And then again, if you wanted legal advice, we can kind of arrange a quote for that. Whereas the relationship property agreements and separation agreements, they're that kind of longer process generally. So it's $450 for the initial agreement. You may choose to take that to your own lawyers, or you might choose to use our online service and get a lawyer each through us. So it's kind of nice and flexible for people, which I think is a good addition to the legal landscape. So, yeah,
for sure. Definitely. Sounds great. Well, thank you so much for your time and thanks for answering all my curly questions.
No worries. Thanks so much for having me, Christine. It was an enjoyable chat. So,
Oh, good. And thanks to everyone that's listening. We will be back next week with another episode of the podcast. If you have any questions for us, at It's No Secret NZ on Instagram. We're also happy to pass on any questions to Will and the Agreeable team. So slide into our DMs. But otherwise, thanks for listening and we'll see you next week.